Good evening, everyone. Thank you for joining us. Regardless of which time zone you're in tonight, we're glad you took the time to join us. My name is Gary Crump, and I am joined tonight by Jared Allen, who is the attorney for our AOPA Legal Services Plan. I'm the director of AOPA's Medical Certification Services and our Pilot Information Center. We're both parts of the AOPA Pilot Protection Services, and we're glad that you joined us tonight on a interesting topic that we've never talked about before, so hopefully you'll find it interesting and get something out of it. For those of you who have participated in our webinars in the past, you'll know that we have taken live questions actually during the webinar itself. We're not doing that tonight. Jared and I both have early morning departures tomorrow to fly out to Phoenix and on to Prescott to attend and be a part of our 4th regional AOPA fly-in at Ernest Love Field in Prescott, Arizona. So if any of you are listening out in that part of the world and don't have plans for the weekend, we would love to see you in Prescott for the fly-in. As I said, our webinar tonight is brought to you by Pilot Protection Services, and we greatly appreciate all of you who participate in the Pilot Protection Services and hope you find and obtain great value for your additional investment in the AOPA products. Tonight we're going to be talking about a subject that we haven't really covered before, but we've always had an interest in doing it because medical certification and legal, whether we like it or not, sometimes kind of run hand in hand. So what we're going to do tonight is cover some of the basics about medical certification standards and the legal side, including enforcements and denials and special issuances. So we'll cover, here's the agenda. We'll just cover things in the order that you see them there. And I'm going to let Jared do most of the talking, even though he's a little under the weather tonight. So he's going to be a little more sedate than most attorneys are and a little bit less verbose, probably.
Thank you, Gary.
Absolutely, absolutely. So let's move on.
Okay, good evening, everyone. And we just want to let you know that, third-class medical reform will not really be an in-depth topic of a conversation tonight. However, we did want to let you know that, at this point, third-class medical reform is not expected to change the current process for the issuance of first, second, or third-class medical certificates for those who do choose to obtain one. However, we certainly do want to make you aware that if you are going to be applying for another medical certificate sometime between now and when the FAA issues the regulations implementing third-class medical reform, that a denial between now and then could affect your ability to operate under this third-class medical reform in the future. And that's because the third-class medical reform eligibility requirements require, among other things, that you have held a medical certificate, whether it's unrestricted or special issuance, within the 10 years preceding the date of the bill's enactment, which was July 15th of this year. And so if you had a medical certificate sometime after July 15th of 2006, you would be eligible. Now keep in mind you just had to have held it. You don't need to have actually had it issued after that date. So you will need to meet that requirement. But for the purposes of denials, another requirement of this legislation is that your most recent medical certificate could not have been revoked or suspended or withdrawn, and that your most recent application for an airman medical certificate could not have been completed and denied. So keep that in mind moving forward in the months to come.
For those of you who have heard any of my talks in the past, I've been doing this a long time. Every talk includes a reference to what I think is one of the most important regulations in Part 61, and it'll gain even more significance as we move into third-class medical reform regulations that Jared was just referring to. That's FAR 6153, Prohibition of Operations During Medical Deficiency. So that's the regulation that requires that we self-certify every time we get in the airplane. Even a lot of AMEs will agree that a third-class medical examination is good on the day it was issued, and from that point on, each of us as responsible pilots have to exercise and pay attention to that regulation and make sure that we actually are fit to fly. Our wellness consultant, Dr. Sakier, always says, you pre-flight your airplane, pre-flight your body as well. So let's just go through that regulation as a quick refresher, and I'll ask Jared to make a couple of comments about the language itself within the regulation. So for operations that require a medical certificate, and keep in mind right now, as Jared alluded to, the new regulations regarding the relaxation of medical certificate requirements have not gone into effect yet. The legislation was passed. So right now, if you want to fly, you have to have a medical certificate if it's an operation that requires a medical certificate. So the regulation just says that we can't act as pilot in command or in any other capacity as a flight crew member while we know or have reason to know, and we'll talk about that, of any condition that would make us unable to meet the requirements for the medical certificate. Now, the requirements for the medical are actually found in Part 67, Medical Certification and Standards, but I want to ask Jared to talk a little bit about one particular little clause there at the very front of Section 1, and that's the requirement that we know or have reason to know. Would you, Jared, distinguish between what that regulation really says?
Certainly. So for knowledge, for the FAA to actually prove that an airman had knowledge of a medical condition that would make them unable to meet the requirements of the medical certificate, you can imagine that would be pretty difficult. The FAA would have a much easier time if they had a direct admission from the pilot that he knew that he was not medically qualified at the time. But as you can imagine, most pilots hopefully don't make those kinds of admissions, so they don't have that. And so the has reason to know language basically allows the FAA to demonstrate that this regulation was violated by circumstantial evidence. And so an example of that is a 1997 case where a pilot actually went to his AME for a new medical certificate. While he was there, the doctor noticed that he had a very significant irregular heartbeat, actually to the extent that the AME called an ambulance to have the pilot admitted to a hospital. And actually, while they were waiting there for the ambulance to come, the AME told the pilot that he was not medically qualified to fly, and that he would have to come back at a later date. So that pilot was admitted to the hospital. He was later released. He was basically told that he may need to have an operation in the near future, and he was given a treatment plan with medications and various other things. And that original doctor actually sent him a letter that said, hey, just to recap what we went over during that appointment, you're not currently medically qualified to fly. We can reconsider this in the future, but for now you shouldn't be flying. But because the pilot's medical certificate, his previous one, still had not expired, he then went and operated 2 passenger carrying flights. The case doesn't say how the FAA found out about those operations, but they did in fact allege violations of 61.53, and the NTSB upheld those violations once they basically determined that the FAA did not have to conclusively prove that this pilot knew that he was not medically qualified, but there was ample evidence to suggest that he certainly should have known that he was not qualified. For example, the letter from the doctor, the testimony of the doctor, the severity of his medical condition that required him to be admitted to the hospital, and certainly the fact that at the time of the flight's question, he was still on at least 4 different medications for the event. So that's the type of evidence that they'll use to demonstrate that a pilot had reason to know of a significant medical condition, not necessarily that he absolutely knew it. They won't be required to go that far.
That's interesting, Jared. You said that's a 1997 case. What's the prevalence of FAA enforcement actions using 6153? Do you see it very much in your LSP practice?
Well, we typically don't see this regulation actually alleged. Now, it's actually surprising because there's surprisingly few cases in the NTSB administrative law judge case decisions and board decisions that actually address this regulation. Now, that could very well be because those cases aren't appealed to the board and the airmen simply accept the sanction that the FAA is imposing. And for a violation of 6153, that sanction can range from anywhere from a 90-day suspension of the pilot's certificates all the way to revocation. And in the case I was just discussing, they in fact upheld revocation of that airman's certificates for what he had done.
That was probably appropriate. Those of us around here often say you can't fix stupid. So unfortunately, sometimes things happen. All right, let's move on because there's more to 6153. There's a part 2, and that regards the use of medication. The FAA is really interested in the medications that pilots use. The Civil Aerospace Medical Institute Toxicology Lab, where they do forensic testing and analysis on tissue samples from fatal aircraft accidents, find quite a few medications that were, in FAA's terminology, underreported on an FAA medical application. Some of them are perfectly appropriate medications, and others are not allowed medications because of the potential side effects or because of the condition for which that medication is treating. But the regulation just says if you're taking medication or receiving other treatment, and that's probably pretty open-ended too, Jared, right?
Absolutely.
For a medical condition that results in the person being unable to meet the requirements for the medical certificate. Again, referring to Part 67. So I usually spend a little time talking about medications too. The FAA does not maintain a complete, comprehensive database of medications that are considered appropriate for flying. They do have on their AME website, the Guide for Aviation Medical Examiners, a semi-adequate list of what they call do not issue, do not fly medications, but they only list different categories of drugs. So in order to find out specifics about medications, your best bet probably is to take a look at our medications database on the AOPA website. Okay, Jared, for operations now that do not require a medical certificate.
Right, and so those typically, as you would imagine, would be things like flying under the sport pilot regulations, as well as glider or balloon operations, things of that nature. It's actually interesting because if you go on to the FAA's website, and at least I've done this recently, when they talk about making the determination as to whether you're medically qualified, the FAQ, which of course is not regulatory, there's a response that, from the federal air surgeon that suggests that you coordinate with your doctor to make sure that you have no condition that would prevent you from this kind of operation. But certainly it's going to be the pilot's own responsibility to make that determination.
Absolutely. Again, pilot's responsibility is relative to 6153. So you'll be hearing that a lot here going forward from AOPA and probably everybody else in the industry as we advance into the new regulatory environment.
Right. And so, Gary, you're asking about regulations we see commonly violated in our practice with the legal services plan here at AOPA. And unfortunately, one of the very common ones when it comes to the airman medical application, which used to be that paper application known as the Form 8500, but is now essentially that application on the MedExpress online, we typically see allegations of what's known as intentional falsification. Like I said, this is a very common thing that we see, and it's also one of the violations that has the perhaps some of the most severe consequences. So in cases where the FAA alleges intentional falsification, what the FAA is typically alleging is that the airman made some type of false statement on the medical application, that statement was in reference to a material fact which the FAA could or did rely upon in considering that in the application. And the case law that surrounds these forms is that every response and question asked on the medical application is a material one, so that's pretty easy for them to establish. And then the third component that the FAA is trying to prove is that the airman made this false statement knowing it was a false statement at the time he made it. And as you can imagine, that gets into proving what was in an airman's mind, so that becomes the point where most of these cases get debated. Now, typically when we're dealing with intentional falsification on the medical application, we're dealing with questions 18V and W. And so, for example, 18V asks the airman to check yes or no, and in part it asks if you have any history of any arrests and or convictions involving driving while intoxicated or while impaired or under the influence of alcohol or drugs. And 18W asks if you have a history of any non-traffic convictions, misdemeanors, or felonies. Well, what tends to happen, unfortunately, is that although these questions seem fairly straightforward, we see many cases where, for example, an airman is arrested for a DUI, but that DUI does not result in a conviction. For example, the case is either dismissed or the airman participates in a ADR program, and so there's no conviction. The airman feels that he doesn't need to disclose this, but the question asks, do you have a history of any arrests and or convictions? So you still have to report the arrest. And so an airman will check no, thinking that, well, I wasn't convicted, I don't need to report anything. And then the next thing he knows, he's receiving a order of emergency revocation from the FAA alleging that he made this intentionally false statement. And so it's very important that you pay very careful attention to both the instructions and the questions on the medical application, because the case law surrounding these applications is pretty clear-cut. They state that the language on this form is basically easily understood by a person of average intelligence, which we certainly hope that most pilots are, and also that you can't not read the application. For example, if you say that, oh, I was just in a hurry, so I was just checking yes or no, or I wasn't carefully reading it, you're basically presumed to have read each of these questions and understood them. So they're very difficult cases to defend. There can be some defenses if, for example, an airman was told by an attorney or an AME that he didn't have to answer a question a certain way. That can affect, how the airman actually understood the question and his response. So you can certainly defend these cases, but they are difficult. So the easiest way to avoid all this is to make sure all your answers are complete and adequate, because if you are the subject of intentional falsification, the penalties are fairly severe. And Gary, if you can click us over to the next slide here. Typically, the penalties for intentionally false statements involve either a suspension or much more commonly a revocation of all the certificates that airman holds, which basically means that the FAA is going to revoke all of your FAA-issued certificates. You're not going to be able to reapply for any certificates for a 12-month period. And when you can reapply, you actually are going to have to go through and take all the writtens and practical examinations for your certificates and ratings. You can take those written exams during your revocation period, but the point is that you're going to have a lot of work getting back to where you were prior to that event. So, like I said, it's very important that if you have questions about those questions on the application, that you give us a call. Because even if you don't make an intentionally false statement, there can be penalties for an incorrect statement. For example, this can involve cases where an airman did not have any knowledge of the fact that he was making a false statement. He could have truly, honestly believed that his answer was correct, and the FAA may accept that as an answer. They may say, we believe you. You did not intentionally make this false statement. Nevertheless, your statement was incorrect. And so if they can establish that, and it's very often easy for them to do so, then they are still going to revoke your medical certificate. However, what they're likely going to do is basically take it away from you, take your medical certificate away, and then you will be immediately eligible to submit another application with the correct statements on it and get another medical certificate issued to you. So there's no 12-month waiting period, but nevertheless, no one wants to have to go through the suspension pending compliance or revocation process for an incorrect statement. So again, if you have any questions about what's being asked on these medical applications, it's very important you get clarification before you fill out those applications.
And a little off-ramp, Jared, in respect to incorrect entries on the application, it's not unusual for pilots to check yes maybe on an application and then go for several years without renewing a medical, and then they go back and reapply, and because they don't have a record of their previous application, they may forget that they checked a yes and actually check no to the same question.
Certainly.
The FAA is very thorough about that. They do not throw anything away. Everything is archived, so they go back and review those applications, and we've certainly seen the FAA in a fairly kinder, gentler way will reach out to the airman and send them a letter saying, hey, on your most recent application, you checked no to this question. However, on the previous application, you checked yes. If you'd like to correct your answer, they will actually send you a hard copy of the front page of the application, the history section, and you're allowed to make that correction on that hard copy page, and then they will accept that, and then they'll also give you a little caveat, hey, be sure to check yes on your next applications. Once it's a yes, it's always a yes because of the language that precedes item 18. Have you ever at any time in your life had, or do you currently have? So that's a little interesting aside that the FAA does try to work with pilots in many of these situations.
Absolutely, and it just proves the point that this medical application is as much a legal form as it is a medical one.
Absolutely, absolutely. One quick side road too, Jared, with respect to reporting under 6115. Do you want to hit on that real quick just to remind pilots on the DUI or the alcohol-related motor vehicle actions?
Absolutely, and under 6115, if an airman does have an event that results in the cancellation, suspension, or revocation of his driver's license, you're going to need to inform the FAA Security Investigation Division within 60 days. You're also going to need to do that if there is a conviction of a federal or state statute relating to the operation of a motor vehicle while intoxicated or under the influence of a drug. And so keep in mind that there may be more than one reporting requirement for a single event. For example, once that action is taken against your driver's license, and then later on if there is a conviction for that DUI. So pay very careful attention to 6115 if you have any event that involves driving while intoxicated or under the influence of a drug.
And take it one step further, if a pilot refuses a breathalyzer, there seem to be two differing opinions here, because our conversations with the docs at the FAA and the certification division say that if you refuse a breathalyzer, it is basically an admission of guilt as far as the FAA is concerned, and they will handle it appropriately. What's the legal advice that you give airmen?
Well, Gary, I mean, that's one of those situations where you see how the FAA treats those refusals to provide a blood and alcohol breath test. They will treat that as perhaps an indication of a person who has a substance abuse or a dependence problem. Now, unfortunately, for many airmen out there, the criminal defense attorneys in your states will often advise you that refusing to submit to a breathalyzer is the best position to take if you are going to defend the case from a criminal perspective. But keep in mind that the FAA simply does not care. They do not care whether your underlying criminal action was dismissed or you went through an ADR program. They will take an arrest, without any further conviction and use that to question your eligibility to hold a medical certificate.
Great. Good stuff. Medical records. Going back to the application, anytime, I guess that's a little broad, but generally, when you fill out a medical application and you're reporting something to the FAA for the first time, be it a new medication that you started since your last physical, you've had medical treatment, you've had a diagnosis of a medical condition, or in your visits to health professionals, you're seeing someone other than maybe a dermatologist or your primary care physician for a routine annual physical exam, it's probably a very good idea to have some type of documentation to support that yes response on the application itself. Because if you don't provide that information up front, most likely if the AME goes ahead and issues a certificate, or certainly if the AME defers the issuance of the certificate, the FAA is going to reach out to you sometime after the fact, probably within a month or so, with a letter requesting additional information to support what you indicated on the application, and they will use that information to establish your eligibility to hold a medical certificate. So anytime you get one of those letters, it's kind of like an IRS letter probably, you don't want to ignore it, certainly. You do want to post haste get all the records that the FAA is asking for. Typically they will give you 60 days to provide the requested information. Sometimes it takes longer than that, even if you're making a really concerted effort because of scheduling appointments and getting records through, particularly if you're part of the VA system, the Veterans Administration system. Those records are pretty difficult to get sometimes. But if you need additional time, the FAA will work with you, as long as you're showing a good effort to provide them the information that they're asking for. If you don't provide it within 60 days, then they do have the authority to issue a letter of disqualification. So you want to furnish the information to the FAA that they're asking for. Don't send them any more or any less than what they're asking for. That's the magic sweet spot, is sending them just what they're asking you for. You don't want to provide a whole office history from your treating physician when all they're asking about is a medication that you've just started taking since your last physical. Also, the regulation allows you as a pilot to authorize any healthcare providers to release that information to the FAA. We highly discourage that. We think that it's appropriate that the pilot maintain the control of that chain of custody of those medical records. So whatever the FAA is asking you for, you get those records from the healthcare facility, your treating physician, whoever. That gives you a chance, number one, to look and see what's in those records. Hopefully you're going to read them to see if there's anything that is in error, because unfortunately there are sometimes errors made in the recording of a medical history. So you can have a suspicion of seizure mentioned in your records when you had a fainting episode, and the FAA is going to zero in on that possible seizure, and then you're going to be providing a lot more information. So whatever they ask for, you get it from your treating physicians. Look it over. Make sure you're sending them everything that they're asking for. Make sure you have some type of identification on each page. A lot of times they will assign you an identification number called a PI number. That's a unique identification number to you once they have you in their medical certification system. So as long as you have some identifying information, because all those records are scanned into the system, the FAA processes thousands and thousands of pages of records every day. So sometimes records get into the wrong place, or they don't get scanned into the system. It's all a digital electronic system out at FAA now. Even though you provide the records in hard copy, they convert those to a digital format, and that becomes the working file that the FAA reviewer is going to be working with. So just make sure you have control over, and you know exactly what the FAA is sending in.
Right, and Gary, it's surprising. Oftentimes when we deal with this regulation from the legal perspective, it's because an airman simply didn't read what the letter was asking, and he set it aside, and that 60-day time frame came and went, and the next thing he knows, he's getting a letter that is basically suspending or revoking or denying his medical application or certificate until he complies with the FAA's request. And you can challenge those actions before the NTSB. However, it's very often going to come down to a very narrow issue, and that is the FAA's request reasonable? And really all they need to do to show that it's reasonable is demonstrate that there's some nexus between the information they're asking for and the issuance of a medical certificate. So you can understand how broad that is, and so oftentimes you're going to have to provide this information sooner or later. And so the best course of action is to get in touch with AOPA or get those records together as soon as possible so we can start reviewing them, making sure there's no other harmful information in there, and basically coming up with a good game plan on how to disclose this information to the FAA.
Exactly. Now let's shift gears a little bit and talk about the chain of command within the FAA. You may be aware that the head honcho at the FAA is the administrator. Right now that's Michael Huerta. But the administrator obviously has a very big job and can't possibly know everything there is to know about how the FAA operates with air traffic, aircraft certification, airman certification, medical certification, and the myriad other things that the FAA has its hands in. So the administrator delegates that authority to oversee the respective operations within the FAA to the appropriate officials within that chain of command. And in the case of airman certification and the medical certification standards, that authority is delegated to the federal air surgeon, who is located in Washington, D.C. The federal air surgeon has many, many jobs too, but primarily by regulation, the federal air surgeon is overseeing the examination process for people who apply for a medical certificate to determine whether they meet the current and applicable medical standards. They're authorizing the AMEs and regional flight surgeons and the docs out at CAMI in Oklahoma City to issue, renew, and deny medical certificates and special issuance authorizations. And we've talked about SI's special issuance authorizations in previous seminars, and many, many of you probably listening to this webinar have a special issuance for one condition or maybe several conditions. And also statements of demonstrated ability, which is a SOTA, which is a little bit different from a special issuance. All this is based on the person's ability to meet or fail to meet the applicable medical standards that are spelled out in Part 67. The authority is also delegated to aviation medical examiners who are physicians who are not FAA employees, but they are designees, just like inspectors and designated pilot examiners. They are authorized and delegated by the FAA to administer flight physicals and to issue medical certificates, and even to, in some cases, to deny medical certificates if the airman presents with a specifically disqualifying condition. Now also the regional flight surgeons, and a lot of people don't realize that the FAA has 9 regions around the country, and each one of those regional offices includes a medical office with at least a regional flight surgeon and maybe a deputy regional flight surgeon and lots of support staff, program analysts, and other people that can help with the review and the processing and issuance of medical certificates to offload some of the workload that goes on in Oklahoma City at the Aerospace Medical Certification Division, which is a very, very busy place. And for those of you who are probably right now waiting for a medical certificate to be issued, it has been taking the FAA several months for the last year or so to get these certificates out. So it's a very busy place, but there's lots of physicians within the FAA system by the delegation that can help with that process. So a denial of a medical certificate, as I said, can be made by an AME. However, the FAA really doesn't encourage the AMEs to issue denials. They would rather get the information in as a deferral, send the application in, and then the FAA reaches out to the airman to request whatever additional information is needed in order for the FAA to review and determine the eligibility for that person to be issued a medical certificate. If you're denied a medical by the AME, by law, by regulation, you can request reconsideration within 30 days. Now again, we don't see this. I can't remember the last time we saw an AME actually issue a denial letter. But if it happens, you've got 30 days to request reconsideration. Now, Jared, here's the deal. The regulation says if you don't request a reconsideration within 30 days, you are considered to have withdrawn the application. That term withdrawn is really not used very much anymore, really since like the light sport rule came out.
Correct, and that's because in a 2007 memorandum, the FAA's Chief Counsel Office basically explained that when it comes to your eligibility to fly under the sport pilot rules, for example, under 6123 and the privileges of exercising a light sport certificate while holding a driver's license or a medical certificate if you do have one. But basically they took the position that a denial that is not then subject to a request for reconsideration, that's basically considered the airman's most recent application. And because that airman failed to ask for reconsideration of it, basically the FAA has taken a position that they've acquiesced to the AME's determination that they were not eligible for a medical certificate. And so, because under the FARS 6123, they talk about your most recent application. Well, your most recent application was the one that was denied by the AME. And so unless you then submit a subsequent application that is approved, your most recent application was denied because you failed to request the reconsideration. So we don't want airmen to have false hopes that if they simply don't ask for reconsideration that they're still going to be eligible to fly under the sport pilot rules.
Right, and that's a key point. Even if you don't request reconsideration, that doesn't slam the door forever, and we get lots of calls about that. Anytime an airman can provide new information in support of the issuance of a medical, the FAA is certainly willing and would prefer to be able to re-examine that new information. And in many cases, if there's a significant change for the better in the condition that resulted in the denial initially, the FAA will be able to issue a medical certificate, probably under special issuance, if not under the normal standards. So don't become discouraged if you're denied, because a denial is not a permanent thing.
Right, and Gary, we talked about this actually earlier this week. But it's interesting when you have these types of situations with the medical certificate that may end up being denied. The time to get more information about whether you should go ahead and apply for a medical certificate or what your eligibility is going to be for medical certification, the time for that is not after you submit an application and you visit the AME. For example, if you have questions, make sure you can answer those questions before you actually fill out that online MedExpress application and then go and visit the AME, because once they download that MedExpress application,
right,
your application is now open and active, and that's going to either have to move forward, the FAA is going to request additional information, and if you try to back out at that point in time because you went into the AME and he did an examination and he found something you didn't like, you can't simply walk away from it at that point. So you really need to ask the questions well in advance to avoid any of these types of issues.
And that's a great point. Many AMEs are very willing to talk to their pilot, their airmen, prior to downloading that confirmation number and bringing the application up into the system. So if you have any issues that you're concerned about and you don't want to call us and talk to us about it, talk to your AME and just make sure that confirmation number is not put into the hands of the office nurse or whoever's taking your appointment and letting you know that the AME is going to be able to see it, because once that confirmation number is pulled up, as Jared says, you can't back out of it. It's a live application. So if your AME is willing to talk to you about it, which hopefully he or she is, then that would certainly be an appropriate thing to do. The other 2 points here, a denial of a medical certificate by the AME as a designee is not a denial by the administrator. So that gets it back into that delegation of authority again. Once it goes all the way to the federal air surgeon, though, it is considered a denial by the administrator through that delegation, and then you have to go back through the appropriate steps to try to get reconsidered. Yes? There we go. All right. This is kind of a rehash of what we just talked about. If an AME issues a medical certificate, it's considered to be a valid certificate unless the FAA comes back within 60 days, at which time they can issue a denial of the application, an outright denial. Now, the reality is that, again, the FAA is not necessarily the most efficient organizational bureaucracy within the federal government, and typically they don't get around to looking at issued exams for probably 3 months or so. The system at FAA is focused on deferred applications. That's where they're putting all their energy, because those are those certificates that have not yet been issued to an airman. So the FAA is really working hard to get those certificates reviewed, or those applications reviewed, so they can issue the certificate to the pilot who's out there waiting for it to be issued. They review the issued exams kind of through the back door on a workload permitting basis. They have gotten better in those quality control review times now, but typically it still doesn't happen within 60 days. And that's significant, Jared, because if it goes beyond 60 days, the FAA can no longer just issue a denial on the basis of the application itself. They have to make a determination that the person is unqualified for the medical and actually issue what we call a letter of disqualification and request that you voluntarily surrender the medical certificate. So the request being in quotes there is important, Jared, right?
Right, absolutely. And, whenever you receive a letter of disqualification, or really for that matter, any letter from the FAA asking you to voluntarily surrender your medical certificate, it's very important that you understand the legal consequences of doing so. And that's because it can really change the legal landscape of how you may be able to retain or at least appeal the FAA's, retain your medical certificate or appeal the FAA's decision. And so, for example, in most cases, certainly not all, but most, once you surrender that medical certificate, another medical certificate can actually only be obtained through a reapplication process where you go and start the process all over again. Or you can challenge that denial. For example, you can challenge that before the NTSB, which we'll talk about in a minute. But the important thing is that if you do go through challenging the denial, the burden is going to be on you, the airman, to establish that the FAA made an error. On the other hand, if you do not voluntarily surrender your certificate and basically hold on to it, then the FAA Medical Division is going to forward this information to an FAA attorney. An FAA attorney is going to review the information. That attorney is going to make a determination as to whether there's a basis in fact or law for what the FAA is doing. And if the FAA attorney does agree, then they are going to go through the formal process to actually revoke that medical certificate from you. Now, oftentimes, the letters that you're going to receive from the FAA right from the start, may have some very concerning language. They may say that, in the future, if you fail to return your medical certificate, you'll be subject to a civil penalty or a fine of $1,500 per day. But it's important to realize that those types of sanctions don't apply unless you actually receive an order from the FAA that is, basically revoking or suspending your certificate. And at that point, you will have to send it in. You will have to surrender it. But at that point in time, you're going to have the avenue of appealing that to the NTSB, and in that proceeding, it's going to be the FAA's burden, not yours, and the FAA is going to have to demonstrate that they have a basis for taking the action that they're doing. So this can be a very complicated situation as to deciding what might be the right avenue, but my point is that don't send your medical certificate in without asking anyone whether it's the best move, because oftentimes if we can force the FAA to actually demonstrate why they're taking the action that they are taking, we can sometimes, prevail, and the airman can keep his medical certificate, whereas if he had sent it in, then that's it. He's in a situation where he's either got to apply for another one, and then at that point, he's got to jump through whatever medical certification hoops the FAA is asking him to jump through.
And similar and a related point, if you have a medical certificate in your possession, and the FAA comes back and issues a letter of disqualification, let's say they issue a letter asking for more information, and you don't get that information into them in a timely manner, they come back and issue a denial letter, a letter of disqualification, and you have subsequently sent the information in and things crossed in the mail.
Absolutely.
So you have finally done your due diligence, and the FAA will certainly review that information. But once they have issued a letter of disqualification, they want that certificate back. And this is where we sometimes differ on our medical certification side from what Jared and his colleagues on the legal side advise, because the FAA will issue what we call a 14-day letter. And they say if you don't surrender your certificate within 14 days, then we're going to take legal action. So even though you provided the information to them and you were ultimately found qualified based on that new information, once they have asked you to surrender the certificate, as far as they're concerned, you got to surrender the certificate. They want it back, and then they'll reissue the certificate if you find you qualified. But until they get that certificate back, they still consider that there is an invalid medical certificate out there in the system, and they won't do anything to work with you until you've given it back.
And that's exactly what I meant by, it really varies on a case-by-case basis, because as we'll go into in a minute, the appeal process is very complex. And what you just said there, that it's going to, if you refuse to give that certificate back to the FAA, they're going to refuse to work with you. And very often working with Oklahoma City may be much more preferable than going through the appeals process, which is often very complex and very expensive. And we'll talk about that here on the next slide.
More time-consuming, yeah. So, what happens when you get denied a medical?
Okay, so whether it is a first, second, or third-class medical certificate, oftentimes one of the first things you're going to do is request reconsideration, because the denial that you receive may not be a final denial. And it's that final denial that needs to be appealed, because anything short of that, the NTSB, the National Transportation Safety Board, which is a completely separate agency from the FAA, but they are the ones charged with reviewing these FAA actions, they cannot review anything that is not a final agency denial. And so when you do obtain that final denial, the FAA is fairly good with including in there the appeal rights that explain how you initiate the process. And typically that means that you have to file a petition for review by the NTSB no later than 60 days from the date of the FAA's denial letter when it was served on you, typically the same day. But once you file that petition with the NTSB, that is going to start the appeals process, and the first level of appeal is with a NTSB administrative law judge. Now, these proceedings are called administrative proceedings. They typically will culminate in a hearing where the law judge himself will hear the evidence and decide the case. There's no jury, but the FAA is represented by an attorney. The airman, or the petitioner in this context, is not required to have an attorney, but it's certainly advised that they have one, because, as I said, these legal proceedings are very complex and there are certain rules of practice that must be followed exactly. And in these proceedings, each party has to present their own evidence, often in the form of the testimony of medical experts who have reviewed all of the airman's medical records concerning the issue. And when it comes to these medical cases, as I alluded to before, the big difference is that unlike other FAA actions, for example, a pilot deviation where the FAA is alleging you violated some sort of operational regulation, in those cases the FAA has the burden of proving what they're alleging. In these medical cases, however, you as the airman bear the burden of demonstrating to the law judge who's overseeing this proceeding that the administrator's, for example, denial of your certificate was in fact erroneous. And really there's two categories of these cases. The first is that a case that involves what the FAA has denied you based on a specifically disqualifying condition, and there's 15 of those conditions here?
Correct.
Right, and so in those cases, really the only issue that the law judge is addressing is whether or not the airman has had in the past or now currently has the specifically disqualifying condition. And it's that airman that has to prove that that condition that the FAA is now citing never existed or does not currently exist. And again, it's the airman's burden to demonstrate that. So you can't expect to show up and have the law judge grill the FAA as to why are you doing this, what is your evidence. The airman has to put on the case, and they have to carry the day in saying, this is what my medical experts have reviewed, this is why they believe the FAA is wrong, and at the end of the day, you have to convince that law judge. And really the second category of these cases is if it's not involving a specifically disqualifying condition, it's a case that basically involves an assessment of medical risk, where an airman doesn't have one of those specific disqualifying conditions, but does have some symptom from another condition that the FAA is saying basically makes them an unacceptable risk to the safety of the national airspace system. And again, it's here that the airman has to establish that, despite whatever medical condition they have, they can safely operate as an airman. It's their burden. The FAA doesn't have to prove anything. They'll certainly present all their evidence that they use to reach their decision, but the airman has to demonstrate this. And like I said, this is a change from how most enforcement cases or administrative proceedings are dealt with. Here it's the petitioner, the airman, who has to really do all the legwork in convincing the judge that the FAA has made an error, and they are very difficult cases. As I said, they involve a lot of attorney time. They also involve a lot of time by medical expert witnesses. And as you can imagine, most qualified medical expert witnesses are doctors who are not cheap. We're talking possibly $600 an hour of their time and up. And it can take tens of hours for them to actually get to the point where they're comfortable testifying on your behalf. So as I was mentioning earlier to Gary, oftentimes working with Oklahoma City can be much more preferable than pursuing these medical appeals. But certainly you can win these cases. The FAA does make mistakes, and so we will work our best to advise you on your options if you have one of these cases. And as I mentioned, that was the first level of appeal. There are subsequent appeal processes where if the law judge makes a decision that's not favorable to you, you can then appeal that decision to the full National Transportation Safety Board, and those are the same people we see on TV overseeing the accident investigations. And then there's another step of appeal all the way out to the U.S. Court of Appeals, the U.S. Circuit Court of Appeals, or the District Court, depending on your strategy. But either way, once you get to that level, it is a very narrow scope of review. They're not hearing any more testimony. They're simply reviewing what's already in the administrative record, the evidence that the FAA used, the evidence that you presented. And so it gets more narrow as the appeals go up, and as you can imagine, much more expensive as well. Gary, do you have anything to add to that? Or?
Well, just you say those cases sometimes are successful. We talked about this earlier today. What is the real likelihood of prevailing in an NTSB hearing on a medical certificate denial?
It's very hard to say. I wouldn't want to discourage anyone, but it's not good. They are very difficult in that typically, as you mentioned, if the FAA has gotten to this point, they've probably done their research. They probably have something in their records. Now, that's not to say, like I mentioned, that the FAA doesn't make mistakes, that there might be some erroneous medical record that is submitted to the FAA by a careless doctor. It certainly does happen, and as you can imagine, once the FAA sees that record, it can be very difficult to change their mind that that was not a legitimate diagnosis or a legitimate condition. And so those are the kinds of cases that are much easier to win than ones where you actually have two medical experts who are debating whether someone actually has a particular condition. Because medical minds can vary, it's a practice of medicine, and so it can come down to the credibility of your witnesses.
Right. And that goes back to the importance of knowing what's in your medical records and picking out anything that is obviously incorrect. Now, getting a physician to change a diagnosis is not what we're talking about, because that probably is not going to happen. But if there is clearly a misstatement an inaccuracy in your medical history, that's something that can probably be corrected by the treating physician fairly easily if it's obviously,
Right, absolutely.
I screwed up, this is not your history. So, but whatever goes to the FAA is going to be the basis for their defense of a denial.
Absolutely. And so we were just talking about the denials concerning, a regular first, second, or third class certificate. Those are typically called unrestricted certificates in the legal world. But you also have the special issuance certificate. And unlike those other certificates, the NTSB does not have jurisdiction to review these FAA denials of special issuance because these are considered fully within the discretion of the FAA. So the NTSB simply will not review them. They will say that they do not have jurisdiction and dismiss the case. There is one appeal process. You can appeal that to the U.S. Circuit Courts of Appeals in D.C. or your home region. Again, it's a very narrow scope of review. Basically, was the FAA's decision supported by substantial evidence? Was it contrary to established precedent and made in accordance with law? Again, it is on the burden of the airman to establish that the FAA didn't have enough evidence or did make an error or did something that is not in accordance with their precedent or policy. Very difficult cases, very expensive, and typically more so here because you need an attorney who is familiar with practicing in these courts, which are one level below the Supreme Court of the United States. These are typically hearings done with a 3-judge panel. They are certainly not judges who take these matters lightly, and as you can imagine, the appeals here are very often unsuccessful because the judges will often do their best to review the record, but ultimately they will sometimes err on the side of caution and defer to the FAA, who, as we all know, is the agency in charge of ensuring the safety of the national airspace system, and no judges want to be the ones who give a airman a medical certificate back when they shouldn't have, who then later goes on to cause an accident. So even though you won't find that in the case law anywhere, that's my personal opinion on it.
Right, exactly right. And actually the German wings accident is sort of in that territory. Terrible circumstances, but he kind of slid through the system and never went through the appeals process. But there were some denials of a medical certificate, and then he was ultimately issued a medical certificate. So that's one of the unfortunate cases that'll go down in history. Well, we've covered an awful lot of territory tonight. I learned something. I always learn something listening to Jared. We have frequent conversations now since we are joined at the hip under the Pilot Protection Services. So it's really good to have Jared and his colleagues counsel on some of these medical certificate cases. I want to thank everybody for joining us tonight. Certainly, if you do have questions, we want to hear from you. Give us a call. I will say we have a brand new phone system in the Pilot Information Center. It went into effect, it seems like 2 weeks ago, but it's only been a couple of days ago. So if you call in and you have some trouble reaching us, I'll apologize in advance. We're still working out the tweaks in our new system. It's a web-based system. It's going to be really nice when we get all the little glitches taken care of. You can also email us at medicalassist@aopa.org. If it is a legal question, we will quickly and readily shuttle it up to Jared and his folks up in the legal services plan to assist in whatever legal question you have about. Certainly about medical certification. That's one of the interesting things. A lot of people will call in and they think they've got a legal issue when it's really a medical certification issue, and sometimes it works the opposite. But we do work really closely together now, and that's one of the really valuable features of the Pilot Protection Services, because you got expert counsel on both the medical certification side and on the legal side. For those of you who are out in the Southwest and don't have anything to do this weekend, the forecast is calling for really pretty decent weather for Prescott for our 4th and final AOPA regional fly-in. So if you got no other plans, we would love to see you. Jared and I will both be there. Jared will be in the AOPA Village at the Pilot Protection Services booth. Marianne Hayes from our medical certification staff will be in the booth next to Jared, and I will be somewhere out on the flight line parking airplanes probably, but I'll be around as well. I will be doing a talk on third-class medical reform actually on Saturday morning. So we'd love to see as many of you as can join us. Thanks again for joining us tonight, and have a great evening.
Thanks, everyone.